Ms. Mayer, you may proceed.
May it please the Court, my name is Sarah Mayer. I'm an Assistant Attorney General from West Palm Beach, Florida, representing the state of Florida petitioner in this case. I'd like to run through the facts with the Court because I'm not so sure they're entirely clear from the briefs. The facts of this case are that Officer Nivens, who was on a routine road patrol, was flagged down by a citizen who said that someone was smoking cocaine in a house down the street, a boarding house down the street. The officer described the building as a two-story wooden frame house with a single entrance in front and a single entrance in the rear. There was a corridor through the center of the building, and down each side of this corridor were individual rooms about 15 feet apart. Each of those rooms was padlocked on the exterior with a padlock that each tenant opened on his own. There were no doors on either end of this corridor. There were hinges, but no doors. The officer testified that he'd not seen doors on that building since 1993. Or he was familiar with the building since 1993 and had never seen doors on it.
And we're talking about the exterior openings, is that
correct.
right? In other words, that's a rear opening to the outside and a front opening to the outside, is that
That's
correct?
The officer entered through the rear of the building.
Were there any fences or gates or walls or anything like that?
There was a fence around the property. It fenced in the boarding house, another house, and a parking lot, I believe, is the way the testimony or what the transcript reflects. It didn't.
Chain link fence with a gate, or do we know?
Someone asked the witness if it was a chain link fence. It was a wire fence of some sort, I think, is what she was trying to say. It's not. She agreed that it was chain link or like that. She said there was a little gate, but that's not developed in the record as to how massive the gate, etc.
This is in the middle of the day, is that correct?
It was late afternoon, four-ish, I think. The officer entered through the rear door of the building, and he testified that the first room to the right was the kitchen. He said he couldn't see all the way into the kitchen from the back door, but if he could see the edge of the table. Moving 4 to 6 feet into the corridor, he could see into the kitchen. Looking into the kitchen, he saw the co-defendant to Mr. Titus, who was sitting at a table with her back to the officer. She was smoking something from what he knew to be a crack pipe. He saw Mr. Titus put a crack pipe in his pocket and start to leave the kitchen. The Fourth District in this case held that a home is entitled to the full range of the Fourth Amendment protection. The state agrees with that portion of the opinion. The Fourth District also held that a dwelling can't be searched without a warrant, which is supported by probable cause. The state likewise agrees that that's correct. The court goes on to interpret and cite McDonald from the United States Supreme Court. This is a case that was decided in 1948, and it has quite different facts from the present case.
While you're talking about different facts, we accepted jurisdiction on the basis of conflict with an apartment search case, all right? Could you argue jurisdiction here? This apparently is a rooming house. Now, clearly there are differences between apartment houses and rooming houses, but are the facts such in this case as to create actual conflict between those decisions? In other words, would you readdress that? Because
Certainly.
if we were talking about a motel room, for instance, it might be far different than an apartment house. What are the facts that really create a conflict here, or are these cases distinguishable?
The state's position is that the apartment house in Batista, which is the conflict case, and, excuse me, the building at issue in this case are very much, they are not, there is conflict. Let me start again. The apartment house in Batista is very much like the building at issue in this case. I think the cases where, or the buildings that would cause a problem would be those in which a former single-family residence was converted into apartments. But here, there is the central hallway, and each tenant's room, his private area, is padlocked and separated from everyone else's. Any tenant could invite any friend to come and visit him. Any person looking for one of the tenants could wander freely through these halls.
But is it the state's position that there is no expectation of privacy in a common area, regardless of whether it's a rooming house or an apartment? Is
Yes.
that the sum of it?
Yes.
Well, does it make any difference what room it is? What if you have a situation in which you do have the kind of converted residence into a situation where a person takes in a couple of roomers and there's a common bathroom? Now, is there an expectation of privacy in the use of the common bathroom?
I think that that's a closer question, and I think that's a circumstance or a factual circumstance that you'd have to look at and see how the areas were used. If, for instance, say to visit a tenant in a house which had been converted, you still knocked on the very front door. People didn't freely open the front door, come in, go up the stairs, and go visit the tenant. Then I think, but had to stop and knock on the front door for the tenant to come down and let someone in. I think there's a greater expectation of privacy than a circumstance where...
Well, that would be because there would be no reasonable belief that others from the general public were going to use the bathroom.
Mm-hmm.
Okay. Is that correct?
Yes.
Well, what was the evidence here that there was a general use of this kitchen by the general public?
There was testimony from the co-defendant that just prior to the officer's arrival, there were 4 or 5 people off the street who were hanging around in the kitchen. But that...
Well, they just come in, or what were they doing in the kitchen? What was the evidence?
She said they wandered in off the street, was her testimony.
Well, let me ask you this.
They were not... I'm sorry.
That's all right. Respond to the question of Justice Wells.
That was the sum total. I'm wondering if the officer, I guess what's important in this case, the officer didn't enter into the kitchen. He was able to observe this standing back in the hallway in the common area and could see straight into the kitchen. It was exactly the same as if one of the tenants had the door to his room wide open and was laying in the bed smoking crack or marijuana or whatever. He didn't go into the kitchen to observe this activity.
Let me ask you this on that matter of where you're arguing that it was in plain view. Before he gets to the point of being in plain view, you're saying because the door was unlocked or because it was opened, that he could go into that rooming house hallway. Am I correct?
Yes,
If, however, the door is locked and only those tenants, that the tenants have a key, that then he can't go in. Am I correct?
he's not privileged to break in if the landlord let him in. I think he would still be in the common area. I think that's,
Would any member
Permissible.
of the public be entitled to do that?
I think so, yes.
Let's say this, that somebody goes in and just happens not to close the door tight, and it's not locked. Can the police officer enter into the house that way
Yes,
because it's not locked?
yes.
And so that the difference is, as far as, and then let's put it with the apartment, if the apartment, which a number now have the common areas have a lock on the outside or a gate on the outside, you need a key card to get in or something of that nature, then the officer cannot go in. Correct?
I don't think that that's the case. The holdings of, obviously the greater weight of authority is that these common areas, that an individual does not have a right or reasonable expectation of privacy in these common areas, where members of the public can freely roam, workmen, visitors. One tenant has no control over
Well,
who
in
another
other words,
tenant
if
invites.
you allow workmen into the common area, that allows then that allows anybody else to come in that finds the door open? They can't be charged with trespassing?
I don't know. Certainly there are cases that say that even where there's a case cited in the state's brief where there's 24-hour security, there's TV monitors, the building was locked, the officer stood out of vision of the TV camera, and when the defendant buzzed to let the confidential informant in, the officer went in with him, and then not the landlord, the building manager let the rest of the officers in, and when they went upstairs, the defendant opened the doorway to his apartment holding a methamphetamine pipe or some paraphernalia that the officer recognized right away. And again, the court found that people simply do not have a reasonable expectation of privacy in those corridors. And the state's position is, certainly in this case, the officer went to investigate a tip. He was in a place where he had a legitimate reason and right to be there. He didn't intrude on anyone's private.
Doesn't all that, though, go counter to your argument that there's conflict in this case? That is really what you're talking about, is how fact-specific most Fourth Amendment law is. That is, you've really painted a very unusual picture here of apparently a rooming house where the doors have literally been removed at the front and the back. So you've got this, it sounds almost like a one-of-a-kind house with not only the hallway now, without doors, but then adjacent kitchens, and were there other rooms, perhaps other rooms in addition to these rented rooms, with padlocks on them.
There was
And here we're taking this on the basis of conflict with an apartment case, and we have the responsibility for determining the law now as it's going to apply, you know, in a broad way here. If it's, you know, we're supposed to reconcile this with the apartment cases, we're going to end up with the search and seizure law to be broadly applied to apartment houses, because that's where the conflict apparently comes from. And we're doing it in a case where I don't know what this place is, whether it's a private, you know, whether it was, you know, originally a private residence. Is that in the facts, by the way? Does
It's
it say
not.
it was originally a private
It's
residence?
not in the
Or does it
facts
say
as,
that in other words, none of those facts are elaborated in the,
and certainly the description of the building itself doesn't lend itself to having ever been used as a single-family private residence.
I
It's-
suppose what I'm saying is that it looks like there's lots of facts there that would have allowed a trial court to go either way. You know, because of the no doors on there, that it, you know, that it's open, and we've got not an anonymous tipster, but an identifiable citizen that has pointed out that, so the police activity in this particular case may well have been justified, including what you say, that the illegal activity was observed from the hallway, not, you know, by going into the kitchen. But I'm concerned that we are taking a case that is very fact-specific and trying to make law for apartment searches. So help me with that.
The conflict is, Batista says that where there are no locked doors, where anyone can enter these central hallways.
I mean, Batista is an apartment house case, right?
That-
At least
It's
that's nice and clear, and there's
perfectly
no doubt
appropriate.
about that, right?
Correct.
This is a one-of-a-kind house case, is it not? Can you point out another place or house in the case law that has a configuration of this place? And it even runs contrary to the usual boarding houses, you know, where the tenants are issued keys, and there are, you know, restrictions on entrance, and you know, each one has its own policy. Is that not true? Boarding houses are going to run the gamut with reference to privacy. You described the differences, I think, in some of the cases you pointed out.
I think there can be a factual distinction with respect to a boarding house, but
I mean, there's no doubt that there's a factual distinction between this case and Batista. That is absolutely clear cut, because we have an apartment house, you know, compared to this unusual place.
Yeah.
But I wonder if we're on safe grounds in trying to make law for apartment houses in a case like this.
I would suggest that this building is very much like a motel, where there are individual separate locked rooms off a corridor.
Well, Batista is not a motel.
But
It's an apartment house, right?
it applies a rule of law that I don't think Batista is fact specific to apartment complex, or I don't think that you can read that decision as only applying to apartment complexes and not to other multi-unit residential facilities.
You think there's one rule of search and seizure law that's going to apply to multi-unit residential places? The rule's the same for hotels as it is for apartment buildings? It's the
Yes.
same for motels as it is for a rooming house where everybody's issued a key?
Yes.
Would your position be any different if this place had doors on it?
I don't think so. I mean, if the public is free to come and go, it's not reasonable to expect to have privacy in those hallways.
But where do you get that the public is free to come and go? You get it from the fact that somebody said there were some people that drifted in off the street in the kitchen, right? You don't get it from for instance, the owner of the building saying that we allow the public to come and go through here. Is that right? It's just from the fact that there were drifters off the street?
I think it's obvious from looking at the building that, one would not...
You think the average person walking down the street and saw that building would feel they can go through the gate and into the kitchen of that place?
Into the hallways, I don't think that...
And they wouldn't be trespassing on private property?
I think not.
Okay.
I think not. I would point, Your Honor, to, I think it's U.S. v. Holland is a boarding house case in which they found that those hallways were common usage were...
Mr. Mayor, let's do this. Your time is up. However, since our questioning consumed the major portion of your rebuttal time, I'm going to give you 2 extra minutes after counsel has spoken for rebuttal.
Thank you.
And we'll also add 2 minutes on to counsel for Mr. Titus and to make up for the difference between the two. All right, Ms. Allen, you may proceed.
May it please the court, my name is Marcy Allen. I have the pleasure of representing Mr. Johnny Titus today, and I have the honor of defending one of the most fundamental rights of our free society, and that's the right to privacy in the home. And to clarify some facts, I have to disagree that to the average human being, citizen walking down the street, that this would obviously be a place that was open to the public.
Well, how more open could you get than to take down the door from the front, take down the door from the back, and just apparently lock the rooms along this corridor? Doesn't this look a lot like a small apartment building?
Now, I believe that the officer's description of the property, the state's witness's description of the property was that this was a 2-story wood frame house with a solitary entrance and a window. The testimony developed that there was a fence surrounding this property and that there was no entrance leading directly, in other words, there was no opening in the gate of the fence from which a person could walk up the front walkway, if there even was a front walkway, and walk through into the doorway. In addition, the officer testified that there was a tree in front of the house and that the branches of the tree obstructed the view of the entrance to the house from the doorway, from the street, and that's at page 14 of his testimony. He then testified that if you get closer, or if you're standing in the back of the house, you could look straight through and look outside. But clearly, this was a fenced, fully enclosed, fenced property. And the officer...
Does it have a gate on it?
It had, according to the testimony, I believe it was Ms. Hudson, there's an entrance, an opening in the gate on the side of the house, so that the officer had to park his car, walk around to the side of the house, and then he didn't proceed to the front door. He continued around to the back, in other words, through the backyard, up the steps, and into the house. Now, this was a house that was not open to the public. The uncontradicted testimony of the officer was entirely consistent with that of the resident and the guest, that this kitchen was not open to the public. It was an area for the use of the tenants only. It was a traditional kitchen, had a stove, had a refrigerator, had a sink, had a table and chairs. I think it would be hard-pressed to say that a citizen, an individual could just come on off the street, walk into this kitchen, open the refrigerator, and start cooking without
But what about the hallway?
invading.
What about the hallway? Apparently, the officer spotted the illegal conduct from the hallway. Didn't have to go into the kitchen.
It's our position that once he crossed the threshold of the residence, that the Fourth Amendment protects entry into the residence. And by crossing the threshold of that residence, he violated the Fourth Amendment because he did not have a warrant or probable cause. The hallway in
Let me
this
ask you
building...
this on the matter of crossing the threshold. If, for some reason, somebody gave him authority to come in there, if it was the manager or whoever the manager of the rooming house, come in, then anything in plain view, he could arrest a person for, correct?
If the officer had the consent of a person in a position of authority to give consent to enter the building, then anything he observed once he was lawfully on the premises would be subject to plain view, certainly.
All right.
And
But the real question is whether has any authority to be there to
exactly.
begin with.
Exactly. And if I just might add on the description of the property, the officer testified that there were no signs on this property to put the public on notice that this was a rooming house. In other words, it wasn't the type of situation where you had, Sarah's rooming house or Aunt May's rooming house on the front of the building so that the public was on notice that this was an area open to the public. I think that once the officer crossed the threshold and he entered the hallway is intimately connected with the kitchen. It's the means by which the resident has to go from his bedroom to the kitchen. Also, Mr. Hudson testified that there was a bathroom in that area as well. Certainly, that bathroom was not open to the public.
Well, what was the testimony? Ms. Mayer referred to the fact that there were 4 or 5 other people that had come in and out of that area. Were those people, what was the evidence in respect to those people?
Ms. Hudson testified that she was asked by her attorney on direct examination whether there were any persons in the kitchen that were not either residents or invited guests. And she said that there were about 4 or 5 people there before the officer came in. The follow-up question was then asked, and were they all tenants or invited guests? And her response was no, they just came off the street. Now, that her testimony is subject to a lot of speculation in the sense that we don't know who these people were. We don't know whether whether Mr. Hudson, my client, was present at the time these people were asked to, at the time these people were in the kitchen. We don't know if he asked them to leave. We don't know if he threw them out. We don't know if he told them they had no business.
Would you agree it would
leaving.
make a difference as to whether, through common usage, this area had people from the community that were just coming in and using the various common areas of the rooming house? Would that make a difference?
No, in the sense that this was that we are entitled to allow people to come into our homes. And in the Dickens case, which is a Supreme Court case from
Will it make a
this
difference
court,
whether you knew the people that came in, or these were people, as Justice Anstead said, were just sort of drifters? They drifted in. And
well, we don't know that they were drifters in this particular case. I think that if you...
But do we know what do we know besides what you've just read us about these people?
Nothing. That's it. We don't know anything. And that's what the 4th District decision went off on, the fact that the inference that was drawn, in other words, that the fact that there were people in the kitchen somehow threw this place open to the public as a I think they used the term 19th century gathering place, isn't a reasonable inference in the sense that there are other reasonable inferences that could equally be drawn from the fact.
Are you saying that was the only testimony about this being a place that was open to members of the public?
That's the only testimony about people being in the building aside from Mr. Titus and Ms. Hudson. We don't know.
Other than tenants and invited guests, that's the only
That's
testimony to establish it was open to the public.
I don't think the problem I have answering your question is I don't concede that establishes that it was open to the public, but that is the only testimony that even remotely could be used to infer that it was open to the public.
How about the officer's testimony? As I understand it, he testified he was familiar with the building from 1993 or whatever. Did he give any elaboration about that? That is, that he had seen that it was open to the public or anything like that?
Not that I'm aware of. I believe his testimony was that he had been to the building between 10 and 20 times in his experience, and we don't know if some of those occasions were after this or not. The case law is entirely consistent on rooming houses. We have the United States Supreme Court in United States versus McDonald first making the pronouncement that there was a right to privacy in the home, and the home in consideration in that case was a rooming house. The McDonald court was careful not to base its ruling upon the method that the officers actually gained entrance into the house, or the fact that they were in a common area, a hallway, at the time they climbed on a chair, looked through a transom, and observed illegal activity. They stated that the tenant in that house had a reasonable expectation of privacy in the entire dwelling. In the Booth case, which is a D.C. Circuit case, and following that, the Bryan case, which is also a D.C. Circuit case, those are both two rooming house cases where a court considered the right to privacy in the entire dwelling. In particular, the Bryan case is very factually similar to our case. In the Bryan case, there was an open door. The door was wide open. The court placed no significance on that fact. They looked at the access that the people had, what the subjective expectation of privacy, and what society is willing to recognize as reasonable. I think that it's very reasonable, and the Bryan court emphasized this point as well. It's very reasonable for an individual to expect privacy in his kitchen, and that's one of the factors that the Fourth District relied on. Then we have the Douglas case out of the California court, which was another rooming house case. In that case, the officer went to the house based upon an anonymous tip that somebody was rolling marijuana cigarettes in the kitchen. The officer stood outside the window, saw the defendant sitting at a table in the house, watched him smoking a brown cigarette. One officer went into the house. And the thing that I get from the Douglas case, in addition to the rooming house aspect, is that the lack of testimony, you can't use the lack of evidence to infer that it's open to the public, because in that case there was no testimony as to how the officer gained access into the house. A second officer then goes up to this front porch, and there's a person, a manager, sitting on the front porch, and he allows the second officer access into the house. The California court was careful not to say, well, because the person let the second officer into the house, we can infer that that first officer also had permission to enter the house. And they threw out the search and seizure, saying that that they were aware of no case, and we are not aware of any case where absent testimony that the residence was open to the public, the officer can lawfully just walk in. And the only case, I might add, that even discusses that is the Anderson case, which the state cited in their brief. And the Anderson case is a rooming house case too, but in that case the court said that there was testimony that the common hallways were used for open to delivery men. Now, we don't have that in this case. We don't have a situation where there was proof that that delivery men were able to walk willingly into this house and drop off newspapers, letters, anything of that nature. We don't know where the mailboxes were. We don't have any of those facts. All we have is a two-story residence that was clearly bordered by a fence, which the residents had a reasonable expectation of privacy. Basically, if there are no further questions from the court, I would ask that the court affirm the district's decision and find that Mr. Titus had a reasonable expectation of privacy in his humble abode. Thank you.
All right, thank you, Ms. Allen. Ms. Mayer, you have 2 minutes.
I'd like to address a couple things. Number one, the McDonald case does note that they don't have, if the officers had been let into the house as opposed to being breaking the landlady's window and coming in that way, the court said, I should say, it's in Justice Jackson's concurring opinion, which is joined with another judge, and then in the dissent to the opinion, there are at least 4 justices in McDonald who say that if the police are legitimately in the hallways, it is not a problem. I think a closer reading of McDonald you'll notice that part of the difficulty was that these officers had been surveilling this defendant for a very long time, and had no exigent circumstances, and there was not a reason why they had not obtained a warrant. And worse than not obtaining a warrant, they break in through the window instead of using the doorways. And I think that's part of the difficulty in applying McDonald.
You do agree in this case that there was no invitation by anybody that expressly invited the officer in?
Correct.
And you agree with the factual circumstance, is counsel for the defendant has said that there was a fence around it, and in order to get into where the house was, you had to go to the side of the house and then through a gate? Factually?
There was testimony that the fence surrounded 3 buildings, and there was testimony that the gate was on the side. We don't have whether the gate was open or closed, whether certainly the fence didn't surround just this structure. And I'd like to, with respect to the trespass issue, trespass is refusing to go after you've been requested to leave. It's not trespass just to be there. It's your refusal to go if requested. And I'm not sure that's precisely the issue that we're dealing with. And further, I'd like to direct the court to the Florida statute on search warrants, which is 933.18, and it defines a private dwelling as room or rooms occupied not transiently, but solely as a residence in an apartment house, a hotel, a boarding house, or a lodging house. The state submits that in this case, the facts are square, that the decision of the 4th District Court of Appeals should be quashed, and this case should be remanded for affirmance of the trial court's order.
Thank you, Mr. Mayor. Thank you, counsel. Court will be in recess for 15 minutes.
Please rise.